Morning. The Subcommittee on Government Operations will come to order, and without objection, the Chair is authorized to declare a recess at any time. Transparency is the lifeblood of democracy, and if a government is truly of the people, by the people, and for the people, the American people need to know what our government is doing on their behalf. Transparency also gives our citizens the opportunity to make informed decisions, to hold accountable those in government that will abuse or perhaps mismanage the public resources. You know, it is those hard-working American taxpayers that really fund everything that we do, and so we need to keep them in mind. And this particular hearing is really to examine the Freedom of Information Act, the tool that it provides, obviously dating back to 1966 when it was originally put in place as a foundational transparency law. And as we've seen it come into practice, those presumptions of allowing federal records to have be accessible to the public is a critical component. Americans really have the desire and the need to know. They're looking in the age of the internet as we start to see information that is coming out. It is critical that that information from our government gets placed in the hands of the American taxpayers. Obviously, sensitive information is something that we need to protect and do that, but under this particular law, what we have seen over and over again is a lack of compliance, a lack of transparency, and unfortunately, when that happens, a lack of trust follows it. And what this is all about is looking at reforms. The ranking member and I both agree that in order to restore trust, you have to have that transparency. With that said, though, there are over 700,000 requests that get made of the federal government each and every year. And so some of those requests can be very laborious. So what we're looking for from our witnesses are to look at how do we streamline the process? How do we make sure that the American people get what they need, that the federal government responds accordingly, and that we put in place a system that truly works? And so we are very thankful for our witnesses that are here today. Chairman Issa and Ranking Member Cummings addressed some of this in a bill last Congress, and indeed they have introduced a similar bill this year, which is H.R. 653, which is the FOIA Oversight and Implementation Act. That particular bill addresses a number of concerns, but what I'm interested to hear from our witnesses today, does it go far enough? What do we need to do? What are some other areas that perhaps the ranking member and I can work on in a bipartisan way to make sure that the American people are informed? And I thank you, and with that, I would recognize the ranking member for his opening statement.
Thank you, Mr. Chairman, and thank you for holding this hearing. Welcome to our panelists. I do want to begin, like you, in acknowledging both Darrell Issa and Elijah Cummings for reintroducing the FOIA Act, H.R. 653. As a co-sponsor of that bill, I'm pleased we're highlighting the issues so early in this Congress, although we see just how much press interest there is in this very sexy subject. But it's an important subject. It may not be headline-grabbing, but it is how citizens can access their government. It is how we hold people accountable. I know that in local government, I was in local government for 14 years in the Commonwealth of Virginia. We have very strict FOIA laws in Virginia, and local government had very limited timelines to respond to requests, and we took it very seriously, and I hope that same spirit will ultimately imbue the federal government as well, Mr. Chairman. This bill would reform a cornerstone of open government law and improve access to government records. One of the important reforms would be to require a single website for FOIA to submit requests to any agency. I think this provision is important because it will allow the government to use technology to improve the FOIA process, both for requests and for the responding agencies. The bill requires the Director of OMB in consultation with the Attorney General, to ensure the operation of a consolidated online request portal. Some agencies, including EPA and GSA, have already been working on such a portal. Agencies would also be required to post online all releasable information that's been requested 3 or more times, and to review their systems of records and post releasable information online if it is likely to be in the public interest. Another key provision of this bill would be to require that agencies notify requesters of their rights to seek assistance from the agency, FOIA Public Liaison, and the Office of Government Information Services. FOIA litigation can be costly and time-consuming. By emphasizing this right, the bill would encourage requesters to utilize dispute resolution and mediation services as a meaningful alternative to litigation. The bill would require the Government Accountability Office to catalog the number of statutory exemptions under B3 and agency use of such exemptions. Individual statutory exemptions are often slipped into legislation without consultation with this committee. We don't even know how many exemptions are on the books. Requiring GAO to catalog those exemptions will help us identify outdated or inappropriate exemptions. I look forward to hearing from all of our witnesses today, and I especially want to make note that we have a former FOIA officer testifying with us this morning. In his written testimony, Mr. Sadler states that many FOIA officers feel that their voices have not been heard. That's a valid point. We have conducted FOIA hearings in the past, but the previous witness panels were mostly composed of open government interest groups and high-level agency officials or political appointees. I commend the work that both of these important groups do. However, I also look forward to hearing the perspective of someone who had to perform ground-level implementation of FOIA. Mr. Sadler has more than 40 years of hands-on experience with FOIA that spans from FOIA denials and appeals to directing FOIA staff at the FDA in their efforts to reduce overall FDA backlogs of pending agency FOIA requests by 91% over a 5-year period. Congratulations, Mr. Sadler. Thank you for your service. I also want to thank Miriam Nisbet for being here today. She has served in government for over 35 years, though she doesn't look it, and is largely responsible for the outstanding reputation of the Office of Government Information Services. Rick Blum, I don't want to leave you out either, because your work with Sunshine in Government has helped give voice to the concerns of reporters, citizens, and other FOIA requesters. Thank you for your diligence and your keeping us accountable to the people we serve. Thank you, Mr. Chairman.
I thank the ranking member for his statement and obviously for his well-prepared opening statement. And I would agree with him. As we start to look at this information, it is critical that regardless of the fact that there are not a number of reporters and cameras there, there's probably no component of transparency that is more critical to the American people than FOIA transparency. And so your testimony, not only will it be constructive and helpful, but it will be vital in terms of restoring the trust in our government that so many Americans want to have. So I thank you. I will hold the record open for 5 legislative days for any members who would like to submit a written statement. We will now recognize our panel of witnesses. And I'm pleased to welcome Ms. Miriam Nisbet, former Director of the Office of Government Information Services at the National Archives and Records Administration. Welcome. Mr. Frederick Sadler, former FOIA officer at the Food and Drug Administration. And Mr. Rick Blum, Director of the Sunshine in Government Initiative. Welcome to you all. And pursuant to committee rules, all witnesses will be sworn in before they testify. So if you would please rise. If you'd raise your right hand. Do you solemnly swear or affirm that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth? Let the record reflect that all witnesses have answered in the affirmative. Please, you may take your seat. So in order to allow time for discussion, you will be giving your testimony. I'd ask that your oral testimony be limited to 5 minutes. If you can, your entire written statement, however, will be made part of the record, and we have that. And so we will first recognize you, Ms. Nisbet, for your 5-minute oral testimony.
Thank you. And good morning, Mr. Chairman, Ranking Member Mr. Connolly, and members of the subcommittee. I am Miriam Nisbet, Founding Director of the Office of Government Information Services at the National Archives and Records Administration. I was privileged to serve in that position from September 2009, when the office opened its doors, until I retired a few months ago at the end of November 2014. Today, I speak as a private citizen who, like you, cares deeply about the right of my fellow Americans to access government information. I appreciate the opportunity to talk with you about the FOIA Oversight and Implementation Act of 2015. The bill covers a lot of ground, so I will focus my comments on those portions of H.R. 653 that pertain to the Office of Government Information Services, usually referred to as OGIS or the FOIA Ombudsman. In its first 5 years, the dedicated staff of 7 put into action the few words that direct its two-pronged statutory mission, providing mediation services to resolve FOIA disputes and reviewing agency policies, procedures, and compliance. By any measure, it has been a success. Why then does H.R. 653 have numerous provisions that directly affect OGIS? The co-sponsors of this bill, as you have already mentioned, and the one passed unanimously by the House in the last session, have stated that the purposes include strengthening the FOIA Ombudsman's Office and increasing its independence, and bolstering the use of dispute resolution in the FOIA process. How would it do that? First, the bill more clearly spells out the responsibility and authority of OGIS to review agency FOIA compliance, to identify ways to improve compliance, and to report broadly on its findings. The changes also would affirm the role of OGIS as a key component in the FOIA ecosystem, as Congress envisioned. Second, the bill would go a long way to making dispute resolution an integral part of the FOIA process. Among the critical changes are that agencies would be required to notify a requester that while he or she may go to court if dissatisfied with the agency's decision, the requester also has the right to turn to the internal FOIA public liaison and to OGIS. Dispute resolution can conserve scarce resources, and it can head off costly and time-consuming lawsuits. Moreover, the availability of dispute resolution at all stages of the FOIA process is just good customer service. Third, the revisions would guarantee independence of the Ombudsman's Office. Congress wisely placed OGIS in the National Archives, an agency whose primary mission is to provide access to government information and which does that very well. Nonetheless, under the law now, OGIS is not an independent watchdog or overseer, as I have heard it described. OGIS is a component of the executive branch and must send its proposed recommendations through the intra- and interagency review process that all agencies must follow, unless there is a specific exception by law. If you want recommendations, reports, and testimony that have not had to be reviewed, changed, and approved by the very agencies that might be affected, then you should change the law. That doesn't mean that OGIS wants to or will be the FOIA police. That role is simply not compatible with the neutral, impartial mediator who brings parties together voluntarily to resolve their differences. However, the authority to report directly to Congress, as H. 653 provides, would be an important reform for an office that hears complaints, resolves disputes, reviews compliance, and is expected to speak truth to power. I might add that if I were still the director, I could not say this. The FOIA Ombuds has demonstrated that it can build strong bridges that make the Freedom of Information Act work more smoothly and move us away from such an adversarial environment. OGIS can take on the additional responsibilities envisioned by H.R. 653, and I hope it will be given the resources to serve both the general public and the federal agencies even more effectively. Thank you. I look forward to answering your questions.
Thank you, Ms. Nisbet. And we certainly, the ranking member and I will certainly have some follow-up. We were whispering, asking some questions as you had that. So the chair would now recognize Mr. Sadler for 5 minutes.
Good morning, Chairman Meadows, Representative Connolly, members of the subcommittee. It is both a pleasure and a privilege to have been invited to join you this morning to discuss the FOIA program in the federal government, and in particular, Representative Connolly, I appreciate your kind thoughts. I would like to note at the outset that my testimony solely reflects my own opinion and is not necessarily that of the department or the agency in which I so proudly served for more than 40 years. In the interest of time, I think I need to focus comments on just a few of the aspects of the draft which have been—
Mr. Sadler, could I just ask you to pull that mic up a little bit closer? Thank you.
All right, I'm sorry. I was not sure how far is that. Okay. In the interest of time, I think I need to focus my comments on a few aspects of the draft which are, in my view, the most problematic. With regard to the foreseeable harm test, if I understand it correctly, the foreseeable harm test would not be applied to those exemptions which are mandatory withholdings, such as national security or trade secrets. However, this means then that the foreseeable harm test would apply to even those exemptions which have minimal discretionary components. I think that as proposed, this has the potential to unintentionally delay the responses issued by federal government, increase backlogs, and almost inevitably result in increased disclosure-based litigation. First, in my opinion, Exemption 2 and Exemption 7 should be exempted from the foreseeable harm test. I believe the statutes themselves and court decisions have subjected those exemptions to the position which basically eliminates the need for foreseeable harm. That would then focus the foreseeable harm test solely on Exemption 5, which appears to be the real area of concern in the requester community. I think it would be beneficial to both public and private sectors to require a breakout of Exemption 5, similar to what we do in Exemption 7. 7 has 6 parts, and you must identify the exemption at the site of every redaction. If you use Exemption 7, we have to say 7A, 7B, and 7C. We could do the same thing with Exemption 5 and separate out those areas which are of minimal concern to the requester community. 5A, for example, could be deliberative and process, pre-decisional process. 5B could be attorney-client communication, and 5C could be attorney work product. And in my experience, general counsel records are rarely at issue in concerns. Portion marking would be new. It would require reprogramming agency internal working and tracking systems and could not be implemented immediately, but it would be both workable, measurable, and enforceable. However, this raises another issue. If a foreseeable harm analysis would have to be in writing, it creates a record which would by definition be releasable under the Freedom of Information Act. And since these are dealing with deliberative matters, by definition, these will probably contain information about pending regulatory issues, public health issues, national security, foreign policy, and trade secrets. And so if a written analysis were to be required and then subject to release, there's every expectation that the analysis could not be released in its entirety. That raises another concern, that the requester community will not have full access to the deliberation and therefore will initiate litigation based solely on a discrepancy of interpretation or a need for additional information. Secondly, the posting of frequently requested records, or indeed all records requested under the FOIA, as has been proposed in some aspects of the media, is probably the single most problematic component to implement. There is a fundamental conflict between the FOIA expectation or statutory mandate, if this were enacted, and the Americans with Disabilities Act. The Americans with Disabilities Act has a requirement within it that requires that all records on federal agencies be audibly read to those individuals who have visual handicaps. That means that the records must be in a specific software program which would enable this. And most federal agencies are creating records in that manner, but submitted records or records otherwise obtained are not. The conversion, which can be done, is called remediation. Remediation is extremely time-consuming and can be extremely expensive, and there is no software program on the market with the capability of remediating records to the extent that a FOIA officer would not have to re-review the document in its entirety, line by line, word by word. I would suggest that the fee structure is unnecessarily complicated and that the basis for this lies in the statute, and it needs to be reviewed in its entirety. If there are issues relating to the granting of fee waivers for media, public interest groups, or nonprofits, it seems entirely appropriate to address those issues, but still to review the overall fee schedule. And then I believe efforts need to be considered which would reduce the impact of disclosure-based litigation. Clearly, the establishment of public liaisons and OGIS have been steps in that direction, and I have had the pleasure of knowing Ms. Nisbet for an extended time, and I've worked with her closely over the past decade, and I would commend her efforts and those of her staff. But there are insufficient incentives for a requester to participate in a mediation process, and all too often they jump directly to litigation. With regard to having all federal agencies update their regulations, 180 days, as stated, is simply insufficient. Double or even triple that amount of time may not be sufficient, depending on the extent of the regulations and the complexity of the records with which the agency deals. I would suggest that Congress consider amending the language within the statute, which is being interpreted as constraining or even preventing Justice Department's revision of administrative portions of the FOIA regulations government-wide. If DOJ had the authority to revise the administrative components of FOIA regulations, the process could be undertaken once. As it's proposed, 99 federal agencies, all of whom are subject to FOIA, will have to go through the process of updating their regulations. The issue of creating a single government-wide portal for submission of a request is very interesting, but it is replete with concerns because this is not well defined. And in the interest of time, I will make one last comment and then defer to the committee and the panel. But I would strongly support the creation of a FOIA council, although I would suggest that the chief FOIA officers are not necessarily in the best position to understand the complexities of the statute, since by definition this is an adjunct duty. You might want to consider making it the most knowledgeable individual at the highest level. I appreciate the opportunity to join you today, and I look forward to answering any questions. Thank you.
Thank you, Mr. Sadler. The chair recognizes Mr. Blum for 5 minutes.
Thank you, Mr. Chairman. Chairman Meadows, Ranking Member Connolly, and members of the subcommittee, thank you for the opportunity to testify today. I am Rick Blum, and I represent the Sunshine in Government Initiative, which is a coalition of the media associations promoting open government. And I can assure you, at conferences and discussions among journalists, this hearing today and your work on improving FOIA is of great interest to journalists. Mr. Chairman, we appreciate your attention early this Congress to strengthening FOIA, and we hope Congress will enact the strongest possible reforms soon. I'd like to use this time to briefly highlight a few points. FOIA remains a powerful tool for the public to learn about matters of public interest. However, journalists and other requesters continue to be frustrated that the process involves long delays and avoidable procedural obstacles. The FOIA legislation addresses these problems with several steps that are very productive, such as strengthening OGIS, all digital processing and tracking, and reining in the secrecy statutes under Exemption 3 that you mentioned, Mr. Chairman. And those laws create anti-disclosure loopholes in the law. First, despite frustrations, FOIA does remain an important tool to document sometimes uncomfortable facts. Armored vests designed to stop bullets failed the military's own ballistic tests, but were sent to soldiers in harm's way anyway. Faced with a reporter who used FOIA to obtain the test results, the military quickly recalled over 5,000 vests. And for the Associated Press, a member of our coalition, FOIA helped reveal that local law enforcement in Ferguson, Missouri, set up a no-fly zone around the protests last summer, not for safety reasons, but to limit media coverage. At the same time, FOIA remains for many journalists a frustrating and broken system. The long waits, avoidable obstacles, and many redactions too often allow agencies to put secrecy before disclosure. One reporter even told me that his initial request for records was denied, and his appeal was handled by the very same office that denied the request. That should never happen, especially with OGIS. That FOIA reform bill, or the FOIA reform bill, excuse me, now before Congress takes important steps to address these problems, and I'd like to highlight them now that are of particular importance to our community. First, Congress should clarify and intends OGIS to speak with an independent, assertive voice. We actively supported the creation of OGIS and support its work today. We even gave an award to the retired director for her work. Nonetheless, many news organizations and reporters have stopped taking more serious substantive disputes to OGIS. OGIS has for 5 years ably handled disputes involving miscommunications and procedural problems and other disputes, while identifying common problems and common sense solutions. OGIS is now positioned to push agencies assertively as appropriate when they refuse to talk or wrongly deny a request. By requiring OGIS to report specifically on its advisory opinions, the bill emphasizes that written opinions from OGIS are an important way OGIS can help correct and prevent agency misdeeds. In addition, before making its recommendations public, as former Director Nisbet testified, OGIS must get input from other agencies and clearance from the Office of Management and Budget. These reviews limit what OGIS can say, delay its recommendations, undermine learning from past disputes, and should be eliminated. To be effective, OGIS requires an independent voice. Next, better electronic tools to manage requests and responses should help agencies and requesters alike. While it would be fun to see a drone-delivered document sometime soon, a good digital system that meaningfully manages FOIA's logistics for both requesters and agencies would be a great next step. In fact, such a system, FOIA Online, is in use by about 11 agencies, and Ms. Nisbet guided its development. The bill's call for a FOIA portal and standards for interoperability help move more agencies into these kinds of systems that talk to one another and avoid paper processing. And that's very, very helpful. Finally, I want to say a word about the secrecy statutes under Exemption 3 that you mentioned, Mr. Chairman. They come up way too often in legislation. As you mentioned, the government doesn't have a good count. By our count, we found about 250 to maybe well over 300, depending on how you count them. And more troubling, we play whack-a-mole, locating and finding these unnecessary, unjustified, and at times overbroad proposals. And this committee has done a great deal of work successfully in knocking these down. They deal with satellites tracking space junk, reforms of the financial system, and plans for high-speed rail, to name a few. And so we appreciate your work on these Exemption 3 statutes and look forward to continuing to bring these to light. In conclusion, Mr. Chairman, H.R. 653 and its counterpart bill in the Senate include many bipartisan improvements, and we look forward to celebrating its quick enactment. Again, we appreciate the opportunity to testify, and I look forward to answering your questions.
Thank you, Mr. Blum. Thank each of you for your testimony. The chair is going to recognize first the gentleman from Kentucky, Mr. Massey.
Thank you, Mr. Chairman. Ms. Nisbet, could you give us an example? A hypothetical is okay, but a real example would be better of how OGIS is supposed to work, and then give us an example of ways that it hasn't been able to function in the way Congress intended. Like with a freedom of information request, a specific one.
Well, as you know, OGIS does have a two-pronged mission. One is providing mediation services to resolve FOIA disputes. And that is something I would refer you to the annual reports that OGIS has made available that details its work. By the end of fiscal year 2014, it had assisted in something like 3,500 FOIA-related matters. And that spans very simple matters from people coming to OGIS because they don't know where to make a request or how to make a request, to much more complex matters that involve real mediation, more what you would think of as mediation between the parties in order to head off
So
litigation.
you've had 3,000 successes, but what's an example of where you've been stymied? And I really appreciate you coming here today as a citizen and appreciate the fact that you wouldn't be able to say some of this if you were still there. So give us an example of what you can tell us today that you couldn't have told us.
Well, the other part of the mission is is reviewing agencies' policies, procedures, and compliance, and making policy recommendations to Congress and the President on ways to improve FOIA. And that is a process, as I mentioned in my oral and written testimony, that did run into problems in that OGIS is part of an executive branch agency. Agencies do have to go through an interagency review process in order to make recommendations, particularly legislative recommendations. Those have to be approved through the process, including through the Office of Management and Budget. And I can tell you that in a number of instances, that was a rather arduous process.
And do you feel that this legislation can make that less arduous?
Certainly I do, because the way the bill is written right now would make it quite clear that recommendations, reports, and testimony will be communicated directly to Congress without having to go through those reviews. And that, Representative Massey, doesn't mean that OGIS would not be regularly conferring and talking with all the different agencies that it works with every day, and being sure to include in any recommendations that it makes the concerns of the agencies. It's not that. It's that those agencies would not be reviewing, approving, and possibly changing those recommendations before Congress sees them.
It sort of defeats the purpose of OGIS if it all has to be filtered in that way before it comes back to Congress, doesn't it, as an independent?
You said that perfectly.
Thank you very much. Mr. Blum, could you give us some specific examples? I know you alluded to a few where you've been stymied or where OGIS was stymied in its ability to help you or the media come to a resolution on a FOIA request. I like hearing the specifics.
Specifics, yes, I mean, very, very much so. I mean, I can tell you that, I guess really a great example of where FOIA wasn't really working well and where we would like to see, OGIS could have a role in speaking out a little bit more forcefully and knocking things down. Or, you may remember the miracle on the Hudson landing when the airplane, was hit.
Sure do.
There was a bird strike, and the airplane had to make that just amazing landing. Well, in the days and weeks after that landing, reporters wanted to know from the FAA, how often does this happen? Is this a persistent problem, or was this just kind of a one-in-a-million kind of thing? And the FAA initially said, yes, well, we have information that airports voluntarily share, and we're going to give that out. And then within a few days, they reversed themselves and said, no, this would affect transportation security, and there's an Exemption 3 statute that allows us to withhold information if disclosure might harm, the ability of us to secure air safety. Well, there was a lot of public attention. Actually, the news media did write about that and did write about FOIA and the limitations. And to their credit, their transportation secretary overturned that and released that information. while safety experts were saying, just mandate reporting, let's get all this stuff in. I think that's a role where it doesn't have to get to that level. And OGIS can say, wait a minute, did you really mean to say that, bird strikes on airplanes, if discussed and disclosed, would encourage someone else to create this kind of accident? That's just not going to happen. So I think that's where we don't, Ms. Nisbet is correct, we don't have a FOIA police, but OGIS is the closest thing that we have. And we'd like some rationality and clarity when these kinds of results happen.
Thank you. I'm particularly interested when public safety is the issue at hand. Thank you, Mr. Chairman, for yielding to me. I yield back.
I thank the gentleman from Kentucky. I now go to the ranking member of the subcommittee, which has jurisdiction over this particular area, the gentleman from the 11th District of Virginia, Mr. Conley.
I thank my friend, the chairman. And I'm going to try to get 3 questions in, one for each of you. So bear with me and try to be concise, and I will too. Exemptions, Mr. Blum. The Constitution does not guarantee access to information. It protects the press, freedom of press. But the dialectic is set up, good luck in trying to get access. And it's really this and other statutes that try to codify that gray area in between in terms of what do you have access to, what don't you. It's the natural order of things. I think government wanted to protect its information and the press wanting to get at it. Not always is the press motivation as noble as you suggest. Sometimes, actually, their purposes may not necessarily serve the purposes of good government, but generally we assume they're truth tellers and they're trying to get at the truth. Could you list some egregious exemptions currently allowed that you think we ought to be addressing in the new authorization?
Well, you said you had 3 questions, so I'm not sure I could make do that question justice. Look, FOIA does lay out a real good structure to identify what information the public should have access to and what interests there are to protect and that justify withholding. And we think that actually is a very good construct: national security, privacy, trade secrets, those kinds of things. But the question that reporters always ask is, why is it so procedurally difficult? Why, if I am, sitting in floodwaters in Katrina and I've requested the test results, why can't I get that quickly? Because the homeowners, my readers, are asking me, when can I come back to my home?
So if I'm listening to you correctly, it's not just about exemptions, it's about streamlining the process as well.
Absolutely.
Yeah.
It's exemptions and streamlining the process. And I think that's what this bill actually does very well, is it does try to address the process.
Well, let me invite you on behalf of myself and the chairman, if I can. We'd love to see a list, if you want to develop it, of exemptions you think we ought to be addressing in the law, because there may be things that escape us we hadn't thought about, but you're dealing with, and that this is the time to try to do that. So if there are egregious exemptions we ought to be addressing, I welcome, I know Mr. Meadows welcomes, you're giving us some guidance in that respect.
I appreciate that very much, and I will.
Thank you.
I will also say, just very, very, very quickly, this bill has been discussed and debated for a very long time, and we really hope that Congress can move on this and get something into law.
Thank you. Mr. Sadler, you made a passing reference to problems with the sort of digital portal provision in the bill, that, yeah, it looks like a good idea, but it's going to be fraught with problems, if I heard your testimony correctly. Could you elaborate just a little bit on that? Because part of our concern is we want to bring the government into the 21st century with respect to technology, especially with younger generations. They expect that it's going to be done digitally, electronically. It's not a bunch of paperwork. This was seen, I think, as something that would be a useful reform, bringing us up to date. So your note of caution struck me, and I wonder if you could elaborate.
Be happy to, sir. When you have nearly 750,000 requests being submitted, if they're all going to go through a single portal, we are essentially establishing an entire division within an agency. This could require a couple of dozen individuals or more to simply log and disseminate. What is also not clear is whether or not there would be a certain amount of oversight, when the log would become public. whether or not the request would be farmed out to the individual agencies responsible for replying, and then the 20-day time period would start. What happens if requests have to go to one agency and there's been a misunderstanding and the request has gone to another agency? At what point did the clock begin? Hypothetically, if you have a food-related issue and you came to my former agency, but the information related to the recall of a meat product, it would be misdirected and would have to go over to the USDA. So there are going to be issues like that. Document size is an issue. Many individuals are using electronic systems which are not capable of either transmitting or submitting sizable documents. That's an issue. There are situations in which individuals request their own records, and in many cases you need an original signature, so there still needs to be some kind of duplication. And in my situation, particularly when you deal with public health, there are many instances in which the letter itself cannot be made public. I find this more often with consumers because they feel that they need to justify what they want to ask for, and will include medical data, Social Security numbers. That happens a great deal with Social Security and Veterans Administration, and the letters can't be made public. So there's an issue about when these will be disseminated. And how that database then would, if it transmits information to a federal government, how it would feed back to a central repository for posting. I'm assuming that you would utilize something like, what is that, FOIA.gov, that's based in the U.S. Department of Justice. But the concept is laudable if you want to simplify access for the public. How we would go about doing that and what restrictions need to be applied. And I'm more concerned here than anything with protecting individual privacy becomes a different issue.
Yeah. Thank you. My time is up, and if there's the opportunity, I'll return to Ms. Nisbet. Thank you.
I think the gentleman and the chair recognizes the vice chair of this particular subcommittee, the gentleman from Michigan, Mr. Wahlberg.
Thank you, Mr. Chairman, and thanks to the panel for being here. Ms. Nisbet, thank you for your service with OGIS, and thank you for your willingness to be able to share things that you couldn't, as you said, you couldn't share if you were still in that position with us today. Let me ask you, when FOIA disputes come to OGIS for resolution, what's the result?
Well, it's varied depending upon what the dispute is. Often, the requester, or sometimes it's the agency that comes to OGIS, there is simply a lack of communication. There has not been good communication, or there's been no communication at all between the requester and the agency. OGIS is that neutral party that can step in and talk to both, find out what the concerns are, and essentially broker an agreement about how long it's going to take or what the fees might be, issues like that. Or if the case has progressed further, really bring the parties together to talk about specific exemptions or where the problems lie. The result, in the best of all circumstances, both the requester and the agency have agreed on a path forward. And the process is streamlined administratively, and hopefully litigation is averted. Certainly that is not always the outcome, but more often than not, the parties simply having that communication, that conversation, really helps the process.
Has there been any significant frequency that information that the agency was reluctant to disclose is now disclosed?
Well, sometimes that happens, but that's only one of many outcomes. The issues may not always be about the information being withheld. It's how the request is being handled, questions about fees, the scope of the request, the search for the documents. So all kinds of issues.
Will the language of H.R. 653 help OGIS get through to agencies, I guess the specific concept that by specific identifiable harm, you really mean specific.
Well, the current policy of the government through the Attorney General's memorandum is that agencies are to identify a foreseeable, that they are not to withhold information if they have not been able to identify a foreseeable harm. And that is built in, of course, to the exemptions as well.
But this bill will help foster that still further, that specific means specific?
It would codify the current policy.
Okay. Thank you. Mr. Blum, FOIA contains 9 exemptions that allow agencies to withhold records. According to administration estimates, only 30% of FOIA requests resulted in full disclosure in fiscal year 2013. This seems low. Is it a struggle to get full and unredacted responses from the agencies?
Is it a struggle? Well, it absolutely is a struggle. It's also very difficult to know once you get the documents back and you see those blackouts, are they appropriate? Thanks to Ms. Maloney, who was very helpful in 2007, agencies now have to say which exemption, which statute they're using and blacking that out. But with deliberative process, it's very hard to, how can you challenge something if you don't really understand the logic behind the redaction? And oftentimes, you don't really see it. There's an organization in the National Security Archive that actually will request something, a couple times. And then they'll compare the redactions, and it turns out that the redactions don't match. And so you get the whole document, and it raises the question of what's really, supposed to be
Persistence pays off
protected.
at that point. Along that line, Mr. Blum, on the President's first full day in office, he issued a memo on FOIA urging agencies to adopt a presumption of disclosure. Attorney General Holder reaffirmed the President's promise for openness. Has the administration lived up to this commitment?
I think the administration has worked very hard to live up to the commitment. They've devoted a lot of hours, holding a lot of meetings with agencies, saying, what are you doing about transparency, and what can you do, and setting benchmarks. They set backlog reduction goals. FOIA is just a very, very difficult process. And so once it gets filtered down, and the procedural obstacles, as I was mentioning, get filtered down to really what reporters are experiencing and other requesters are experiencing, it's very difficult to see the changes come to life. So that's why we think that it's very appropriate for Congress to try to streamline the process, to try to make the procedures work better. So at least you're taking out all those, process battles that reporters talk about. Oh, I finally got them to change my address, so I'm actually getting the request to the right place eventually. I'm getting an estimated completion date. You shouldn't need that. You should be able to look at the statistics and see, okay, for a request like mine, it takes the FDA 60 days to do this, it takes them 15 days to do that, and I'll call them back, and I'll keep tabs on my request. So I think the procedural, fixes in the bill just are real common sense, and I would hope that they would not be perceived as controversial in any way.
Great. Thank you. I yield back.
I thank the gentleman. The chair recognizes the gentleman from Massachusetts, Mr. Lynch.
Thank you, Mr. Chairman. And I think this is your inaugural hearing as chairman. So congratulations, and I think it's a very important topic. I want to thank the panelists for helping us out. This committee especially, we're charged with government oversight. And frankly, the scope of government activity and the complexity of that activity and how it affects the American people requires us really to rely on the public through FOIA to almost be like, a million private inspectors general. So all these 700,000 requests a year actually amplify what we are struggling to do here on the Oversight Committee. So we really have a keen interest in making sure that we adopt some of the reforms that you've spoken about. I think it's very, very important, to the public trust. And when you get these long delays and sometimes unreasonable obstruction by these agencies to very important requests from our citizens, that's an attack on democracy in a very real way. Mr. Sadler, you talked about in your testimony a very interesting issue regarding Section 508 of the Americans with Disabilities Act, that provision protects disabled individuals from discrimination when they request information. As you explained, Section 508 requires agencies to ensure that persons with disabilities have comparable access to data as persons without disabilities. This means that a record posted on an agency website has to be accessible to blind individuals through text-to-speech software. And you mentioned that we're simply not there yet with some of this software. Can you explain the process that the agency is engaged in trying to make sure that the freedoms and rights within the statute are actually being met, or at least we're working toward that point?
It's a difficult and complicated question to answer, so I'm going to try and keep my responses short because
Right.
I think that you have honed in on a particular concern. If the FOIA at the moment for posting is a policy and the ADA is a law, and the FOIA officer has to choose, because of resource issues, which to meet, they will meet the requirements of the law. If the FOIA requirement for posting frequently requested records or more were to become law and there is no increase in resources, the FOIA officer will have to choose which statute to violate.
Right.
I can give you numerous examples, but when you think about it, remediation does not work for anything that is handwritten, foreign languages, computations, graphs, charts, and photographs. So when we look at the concept, it's problematic from a conversion standpoint. And I'll give you two examples, neither of which are intended to be flippant, but may be perceived as such. So if that's the way that it comes across, I will apologize up front.
Okay, fine.
We had a document that was 250,000 pages that was required to be made public. We did not have the resources internally to ensure that that document was posted and made publicly available in a 508 compliant manner within 20 days, and went to try and contract it out. The remediation costs, low bid, was $90,000 for a single document. This is not a sustainable cost level given the volume of what we're handling. Yeah. The other problem is remediation will pick up every little nit and unclear line as part of its optical character recognition. An A becomes an E, an I becomes an L, and therefore it is rendered illegible and unusable by the visually handicapped. Again, not to be flippant, but we issued a letter to a food company for distributing power bars, breakfast bars kind of thing, which did not include specific ingredients that were required to be included by law, specifically ingredients that were allergy-inducing. And in this case, the firm did not put peanuts on the product labeling. The letter of admonition came to my office for posting. It came to us in Word, and at that time, it could not be remediated easily, so we went through the process and posted the letter. Unfortunately, the phrase allergy-inducing ingredient was mistranslated by the optical scanner as orgy-inducing ingredients, which was publicity that the firm couldn't buy. Everything had to come down immediately, and all of the documents have to be reread line by line, word by word, to ensure that they are appropriately remediated. The alternative is to obtain a temporary waiver to post unremediated documents. We've done this on numerous occasions, but on day 21, the document must either be remediated or removed. We've had 3 separate lawsuits, unrelated, for 22,000 pages of pacemaker materials where the pacemaker lead deteriorated in place between the pacemaker and the attachment to the ventricle. The documents were requested, litigation ensued in all 3 cases on day 21, and we agreed to post the documents free of charge on a rolling basis. But on day 21, everything had to come down.
Yeah.
We can redact the document electronically and burn it to a CD. I can keep that in a public reading room, and I can continue to provide that to a requester with a 24-hour turnaround. What I couldn't do was leave it online.
Yeah, no, I understand. Well, we are certainly open and eager to make sure that handicapped individuals have access to this. That's the I guess it's the aspiration of the legislation. That's our goal, and we need to figure out, like you say, it could be a question of resources in some cases, but we have to make sure that we follow the letter of the law and make progress so that handicapped individuals have this right. And I thank you. You're very articulate in your response. I appreciate it, and I yield back. Thank you, Mr. Chairman.
I thank the gentleman. The chair recognizes the gentleman from South Carolina, Mr. Mulvaney.
Mr. Sadler, let's stay on that topic, because I picked that up during your initial testimony, and I want to follow up on some of the things Mr. Lynch was asking you about. So are you telling us that every single document that comes into your office has to be remediated at some point?
Yes, sir.
And that is also, every single document then needs to be,
When it's posted.
okay, when it's posted, has to be checked. So someone has to sit and listen to the remediation while they're looking at the document to make sure the remediation is accurate.
You wouldn't necessarily have to listen to it, but what you would have to go back and read it to ensure that the remediation correctly interpreted the characters that are on the page. And as I say, that mathematical computations, photographs, foreign languages, handwritten comments will not remediate.
And I'm not trying to be difficult, but you'd have to listen to it and read it at the same time when you make sure that it's been remediated accurately.
If it's remediated, then correctly, it would be read correctly.
Okay. I'm sorry, so someone actually reads it out loud? I thought you said
If you're
before there was a
visually-
piece of
if you're-
software that does this.
If you are a visually handicapped individual, you need to be able to sit at your computer
Right.
in your place of work or your home and access any federal government website, look at a particular document, hit it, and then your software will read that document back to someone who's visually handicapped. That's the purpose of 508. I'm not sure if that answers your question.
Do you guys have any idea what you spend on this?
Not a clue. A great deal of it is done internally. Shorter documents are done that way. And at this point, because the Attorney General's office and DOJ has been monitoring this beginning in 2007, they did a government-wide survey and requested a schedule for full remediation. And I have seen Department of Justice, Office of the Attorney General instructions on continued remediation practices in 2011. Most government documents are being created in a remediated manner. So what we're talking about under FOIA are submitted documents or records that were otherwise obtained by a federal agency and then redacted and posted. So a change in this to permit posting of unremediated documents, by definition, in my opinion, does not need to include anything authored by the government.
What percentage of the FOIA requests that you deal with are from folks who are visually handicapped and need to have the documents in audio fashion?
That is not tracked, and we had a caveat on the website that if there was a problem, that they should call the public liaison, which was me, and ask for assistance, and we said that we would make that available. I never received a phone call in 40 years.
Mr. Lynch, and if I may enter into a brief colloquy, what I'm trying to get at, if there's a better way to do this.
All right.
Because it sounds like it's a logistical nightmare. It may be a financial burden on the folks who are required. It almost sounds like it'd be cheaper to have somebody read it out loud to them.
Yeah.
To actually hire somebody to simply read it to them than to have all the documents available in that particular fashion. So that's what I'm
Right.
just trying to get to. I'd be curious, maybe we'll follow up with you after the hearing, as to whether or not you have, well, I'll ask you now, since I've got some time, do you have suggestions on how to fix this and make it easier, still meet the goal, which is still provide the documents to the folks who are disabled, but do so in a fashion that doesn't cripple your ability to deliver information?
In the absence of additional resources or funding specifically designated to meet the 508 compliance, I don't see how it can be done, because unless you want to expand, a personal opinion, sir, but unless
all
you
I'm
want to, okay, unless you want to expand the resources that are available to individual IT programs, security programs, FOIA programs, even Privacy Act and proactive posting becomes a nightmare that way. But unless you want to expand the resources, I don't see how they can keep up unless they divert those scarce resources from another program.
Which will continue to subject you to various lawsuits.
It would, sir.
Thank you. I yield back the balance of my time, Mr. Chairman.
I thank the gentleman from South Carolina. The chair recognizes the gentlewoman from New York, Ms. Maloney.
Thank you, Chairman Meadows, and congratulations on your new appointment. And Congressman Mulvaney, I think you had some good points about how we can make government work better. And I want to very much congratulate Ms. Nisbet on her service to government, and having served as the very first director of the Office of Government Information Services. Congratulations. As you mentioned in your testimony, Ms. Nisbet, OGIS is an office that was established in 2009 to act as the FOIA ombudsman by mediating disputes between FOIA requesters and executive branch agencies. Would strengthening the independence of OGIS also help the agency better carry out its mission as a mediator?
That is a question that I will try to parse through. The independence of an ombudsman is usually one of the criteria for having an ombudsman, because you want an impartial, fair mediator who can convene parties, who can also just hear complaints, systemic complaints, for example, or to be able to hear complaints that come from a range of agencies as well as requesters, and be able to put those pieces together, and then to be able to report on and make recommendations for how improvements could be made. So I believe that the independence issue is helpful both to the review and recommendation portion of the mission, as well as to the mediation.
And Mr. Blum, congratulations on your many years of service for Sunlight in our government, and I really believe that organizations such as the Sunshine Government Initiative will take a more and more of an important role with the really assault on the independence of our newspapers. So many of them are facing financial challenges. Many have gone out of business. Many are merging. So that strong third wave that was able to really research and comment on government with the changes in the media are becoming weaker. So therefore, your position is all the more important in what you're working on. Do you think that there is ever a role, Mr. Blum, for OGIS to issue advisory opinions? As you know, where mediation has not resolved the dispute, advisory opinions can be issued, and what is your take on that?
I think it would be very helpful. In fact, I think that in certain circumstances, if an agency, is wrong in its interpretation of FOIA, or if a requester questions it and feels like they're kind of being jerked around, it's really helpful to get an independent take on the situation, and that's what OGIS was intended to do. It doesn't guarantee that newspapers or other requesters get what they want every single time, but provide that independent lens to say either the agency was right, or the agency was justified, or the agency was wrong, and they call it out. Other bodies that deal with ethic issues in the federal government do create advisory opinions as an administrative record to help not just requesters, but to help agencies avoid a future dispute. If somebody that's working for Mr. Sadler, or Mr. Sadler himself, has a question about how to interpret something, there's a novel or complicated request, I think it's very helpful to have as much guidance as possible. There are 700,000 requests that come in every year. Surely an agency has dealt with the same issue in the past, and maybe someone could write up what happened and what's a really good common sense interpretation of that. It would be good to be able to refer back to that experience. So I certainly think that would be very helpful.
The complaint that I hear from whether it's individuals or the press is often how long it takes. And I believe that you're supposed to respond within 30 days of a request of an agency. Is that correct? But what happens if the agency doesn't respond? What recourse does an individual or the press have to get this information? And oftentimes you're on deadlines. You may have votes that the information might impact your vote, or stories that need to be filed. So could any of you, if anyone would like to comment on it, on the time frame? I believe it's 30 days you must respond. What happens if you can't respond, or they don't respond? What recourse is there for the press or others to get the information?
I'll take it.
I'll do a follow-up. Go ahead.
We're fighting over answering your question here, all three of us.
We're not fighting.
That's not normally the problem we have here.
I think we all want a piece of that question.
Yes, ma'am.
But I think I've resolved the dispute, and the gentlemen are very kindly going to let me answer that real quickly. The statute allows 20 working days, so that is working days in order to respond. And really, there are a couple of recourses for a requester when the time limit is approaching or has passed. Certainly, filing an administrative appeal doesn't help at that point, and the statute says a requester can go to court, can go right to court if the statutory time limits have been passed, which is why having an alternative, having the requester be able to go to the FOIA public liaison for assistance in working on the scope of the request, the search, any kinds of procedural questions, or coming to OGIS, and the changes in HR 653 would allow a requester to resort to the FOIA public liaison and to OGIS in order to avoid having to go to court, which I think most of us would agree would be a very, very good alternative.
Thank you so much. And the chair recognizes the gentleman from Georgia, Mr. Carter.
Thank you, Mr. Chairman, and thank all three of you for being here today. I'm going to start off with Mr. Blum and ask you a question. You made a couple of interesting comments earlier that I want to expound upon. First of all, you talked about Ferguson and about the no-fly zone that was imposed there.
Right.
You said that it was initially thought to be because of one reason, but it turned out to be because they didn't want the media to actually cover the event?
Right. The Federal Freedom of Information Act was really critical for the Associated Press to obtain the audio recordings of conversations between FAA officials and local officials. And I guess the concern, as I understand it, was not with the commercial traffic that was in that area, but really you can tell from the audio tapes that it was they just didn't want the media there.
So that was a subjective interpretation that you made of that?
Well, I think the reporter had the audio files and was able to document that.
Okay. But still, it was somewhat subjective in the sense that he interpreted it as being that was the reason.
Yeah, I mean, I think it goes to a larger point that, you know, we all want to protect the ability of law enforcement to do their jobs and not have disclosure disrupt that process. But there are times when we really do want to make sure that law enforcement are doing the right thing. And maybe it was perfectly important to have a safety zone. And that's the call, but it's got to be for safety reasons, not.
Okay, and that's just the point I'm trying to get at. Is that there? You know, it is a fine line. I mean, it's very difficult sometimes to judge that gray matter, if you will.
I completely agree.
Okay, and then the other point that you made that I want to touch on was about the Miracle on the Hudson, and the FAA was slow or hesitant to release the information because of what reason, did you say?
Well, they cited one of these Exemption 3 statutes. Exemption 3 of FOIA says that if there's some other law in the book somewhere that denies, you know, that puts information behind closed door, that FOIA wouldn't trump that. And that was in the original statute. And so they cited one of these that gives specific criteria to the agency to use. If the disclosure would inhibit the security of aviation and other transportation. They cited that as a reason to not give out the data that they had voluntarily collected from various airports about wildlife strikes.
Okay. Well, let me interject at this point now that I'm all in favor of freedom of information, and I want to make that clear. Mr. Sadler, I want to speak to you as in your experiences with the FDA. Yeah. And I'm assuming that you did more than just food products, that you did medications as well.
Yes, sir.
Okay, well, I'm a pharmacist, and I want to ask you, are there ever any inquiries that you had that you were hesitant to release some of the information for fear that it might create panic within the citizenry, especially as it relates to medications, that you know, they might stop taking their medications, that you know, we struggle with compliance as it is? Did you ever run across that?
No, sir. What I did find was that FOIA functioned well when it worked with our Public Affairs Office and Legislative Affairs Office, and in situations where we thought there might be public concern, we would create individual pages And as documents were reviewed and redacted, they were automatically uploaded in a manner of proactive disclosure. And a perfect example would be when the Chinese growers were using a pesticide on wheat products that was banned in North America. That wheat product was then shipped in a contaminated form to Canada, converted into a dog food in the United States. There were more than 40 different brands that were impacted. We issue bulletins, work with public affairs, created a page specifically to address that. We've done the same thing on issues of pediatric vaccines as it impacts on autism.
Good. You're touching on something that is good, because vaccines came right to my mind whenever I was thinking of this.
We had litigation against the agency with more than 1 million pages at issue, which required bringing in multiple attorneys on contract. Part of the difficulty that we experienced, personal opinion, was that the attorneys were looking for long-term employment in permanent positions rather than as contractors, and they bailed as soon as they could find an alternative employment, setting back the agency's ability to respond to litigation in a timely manner. The volume of requests is a problem. You can't remediate some of these things, particularly when you're dealing with truly old records and they're bad carbon copies. I think the agency has addressed public health issues quite well. And we do make available individuals to discuss these kinds of problems with individuals if they wish to pursue communications.
Okay. Well, I think I'm out of time, but thank you very much for
May I add a parenthetical here? And this is a response to a couple of different questions, and I apologize for going over time, but I think in this statute I'm hearing a conflict potentially between the functions that are dedicated to OGIS and the functions that are dedicated to the Department of Justice. I would suggest that there be a clear line in defining the functions and processes of these two groups. The Office of Information Policy and the Department of Justice is designated by statute as the arbiter of policy and interpretation, and OGIS is there to monitor, look for improvements, and then to work with the requester community for mediation. I think there is some commingling of these functions that's going on, and if that happens, a FOIA officer could, in theory, receive different responses to the same question. I would like to see a more definitive break between the two organizations. They work hand in glove. There's a highly cooperative relationship. They frequently do training together. My friend, Ms. Nisbet, is a long-term friend of the head of OIP, Ms. Puste, and we all get along well. But it is confusing sometimes to both the FOIA community and to the requester community as to where you go.
All right. I thank the gentleman from Georgia. I thank you for your response. You're drawing the scenario that you all get along well. I want to come back and visit that, because that is not what I'm hearing. So we're going to go to the gentleman from Wisconsin, Mr. Grothman.
Thanks much. For Mr. Blum, you have these, there are exemptions from Freedom of Information Act under what you call B5. First of all, can you tell me about how often that exemption is used?
I'm sorry?
Can you tell me how often that exemption is used, the B5 exemption?
It is used, I believe it's thousands of times every year.
Are there any times where you think it's inappropriate? Like, you give me the examples where you think it's wrongly used?
Well, the VA blocked the names, they declined to name hospitals where 19 veterans had died during delays in medical screening. Bureau of Prisons refused to release names of companies that had contracted to have access to prison labor, and they used B5. My understanding is the CIA claimed B5 to withhold the history of the Bay of Pigs invasion. Again, I'm going to cite the National Security Archive, this independent group for collecting these examples. I mean, the issue is not, do people in government have the right to sit in a room and deliberate policy and come up with something that's good for the country? The issue is, do they have the right to abuse that privilege? And we hope that what's in the bill will help, stop that.
Okay. Ms. Nisbet, just a final comment from you. When I look at this area of the law, I see, two problems. One, the one we just kind of talked about, in which agencies are either delaying or not turning around requests quickly enough or denying requests. And the other problem is somebody who's been in government for a while, people can just pester you forever, and you have to spend forever and ever responding to these requests on fishing expeditions. It just takes a tremendous amount of time. Could you give me, based upon your years of experience here, your suggestions for improvements in both these areas?
Well, I think an improvement has already been introduced into the law with the 2007 amendments, which did create a chief FOIA officer, made statutory the position of FOIA public liaison, and created the FOIA Ombudsman's Office. I think with both delays and with problems of, let me just say, maybe frequent flyer requesters is sometimes how they're referred to, people who just keep coming back and back. And in fact, maybe their issue is really not the FOIA. It's an underlying problem with the agency or with issues that the agency deals with. In both of those situations and other related procedural matters, having an office such as the FOIA Public Liaison or OGIS to be that neutral mediator, to be able to sort of calm the parties down and bring them to a place where they can actually have a conversation or even a mediated conversation, can really make a difference, and we have seen it work.
I thank the gentleman from Wisconsin. The chair recognizes the ranking member of the full committee who has, over the years, has talked about restoring trust, and that's a big item for Mr. Cummings, and so it is with great admiration. The chair recognizes Mr. Cummings, the gentleman from Maryland.
Thank you very much, Mr. Chairman. Mr. Blum, earlier this month, Representative Issa and I introduced H.R. 653, the FOIA Oversight and Implementation Act. The bill codifies in law a presumption of openness. The bill does this by creating a legal presumption in favor of disclosure in response to FOIA requests. When President Obama took office, he issued a memo that directed agencies to administer FOIA with, and I quote, a clear presumption in the face of doubt, openness prevails, end of quote. Is that accurate, what I just said?
Yes, sir.
Okay. The bill requires that records be disclosed under FOIA unless agencies can demonstrate, quote, specific identifiable harm, end of quote. In 2009, Attorney General Holder issued a memo instructing agencies that the Department of Justice will defend FOIA denials only if, 1, an agency reasonably foresees that disclosure would harm an interest protected by one of the statutory exemptions, or 2, disclosure is prohibited by law. Is that right?
Yes.
Now, Mr. Blum, you said in your testimony that you agree with adding these provisions to the FOIA statute. Let me ask you this. If the agencies are already required to do this under the administration's policy, why is it important for Congress to pass these provisions in the law?
Well, I think it's very important to take the 6 years' experience that agencies have had and put them in the law to assure that that's the way going forward, you know, in the next administration and the next administration after that, that's the appropriate starting point. You start in our democracy with the presumption of openness unless there's a very specific, reasonable a reason for not being transparent. And so it's important, I think, for future generations to have this in law.
Now, last year, the Department of Justice expressed some concern with this provision, suggesting that it might increase litigation and undermine the policy behind the exemptions. Mr. Blum, this bill would just codify DOJ's own policy. Is that right?
That is true, yes. It would just codify the Justice Department's policy.
So I take it that you don't have similar concerns.
I do not. I do know that very, very late in the last Congress, some concerns were raised, but the issues that they had raised, I just don't understand, because there are already broad protections for some kinds of information that they were concerned about.
The committee has also heard from some independent agencies that the presumption of openness standard might impact their ability to withhold certain information, specifically the Office of Controller of the Currency, the Consumer Financial Protection Bureau, and the Federal Trade Commission suggested that the bill could impact their ability to obtain information when they conduct exams of institutions they regulate. They suggested that banks and other regulated entities would not have certainty that the information they provide would be protected. Mr. Blum, how do you respond to those concerns?
Well, I really don't understand those concerns, because Exemption 8 already covers, already a category that protects financial information, Exemption 8. And it's very, very broadly interpreted as a very broad protective exemption. And it was clarified to ensure that the SEC's new authorities under Dodd-Frank, could use Exemption 8. So I really think that there's already very, very broad protections for this kind of information.
So is there any reason to believe that the information that an agency is legitimately withholding under Exemption 8 would lose its protection under the bill?
I really don't think this bill would change that or have the kind of damaging impact.
All right, thank you very much, Mr. Chairman. I yield back.
I thank the gentleman. The chair recognizes himself for a series of questions not to exceed 5 minutes, and I want to just say thank you. And before I go any further, I want to publicly thank the staff that has worked so diligently. They normally are not the ones that are speaking, but they're always the ones who are doing the work, and so I want to recognize them and thank them for their work. Mr. Sadler, let me come to you. One of the quotations that I wrote down is that you said there's a tendency to, quote, jump to litigation, unquote, when you were talking with that. Why do you think that would be, Mr. Sadler?
Strictly personal opinion, sir. But I think that there is a belief or an understanding on the part of a small segment of the requester community that FOIA is being given less attention than it is, and I don't think that these individuals necessarily understand the complexity of the implementation, and they believe that they can then force production of records within a relatively short time. And, of course, one of the financial changes that was made is that if an agency did not respond previously and then did during the course of litigation, the requester could ask the court to award attorney fees, which an agency would have to pay out of its operating fees. This can run into the hundreds of thousands of dollars. In bygone years, attorney fees would be handled by the Department of the Treasury from the Judgment Fund. That's no longer the case as of 2007. We've lost a couple of cases in my agency, usually as a result of timeframes or volume or complexity. But we did have one case where we had to pay $246,000 out of operating funds.
So how do the complaints that we get from folks that Mr. Blum talks to, actually people that have called me prior to this hearing, says that on a number of occasions they feel like they just get stonewalled, that what happens, the Freedom of Information officer may want to comply, and all they're doing is coming back and saying, well, we can't get the information, we can't get the information, we can't get the information. Would you say that that is an accurate characterization of the issue?
I think it has happened on occasion, without question, sir.
All right, Mr. Blum, would you agree with that?
I would. Often the FOIA officer is the one trying to get the records out and having difficulty.
So we need to empower the FOIA officers. How? I mean, because are they handicapped?
Well, I think the higher the attention within the agency to these problems, the better.
So if there's a problem, a memo needs to be sent to the ranking member so he can justify that?
Well, I think having performance metrics that an agency head or their deputy can look at to say, look, we've got a backlog in this office, who else can pick up some slack? Or why are we not doing as well as we need to? And let's put some more resources to help people like Mr. Sadler. Those kinds of things can be very effective, and I think the bill tries to do some of that.
All right. So how do we go about, Ms. Nisbet, how do we go about limiting the scope of a FOIA request where it is saying, don't send me, please send me 100,000 copies so I can go through and do the research, and make it much more, perhaps what I would say, a rapid response. If they will make it a much smaller request, they get a much quicker response versus saying, we have this broad brush we're going to stroke it with, and we'll comply with that, but that may take 12 months to comply with if you will narrow the scope in terms of your question. Is that something that's reasonable?
It is very reasonable, and I think it's happening more and more, but that is precisely where you need the FOIA public liaison or OGIS to be able to have that conversation. In other words, you really need to have the requester and the FOIA office talking about what kind of records there are, what there might be, what could be gotten very much more quickly, as you say. That also, Mr. Chairman, requires trust. And that's often lacking, I think, because until recently, there has not been an alternative other than litigation, and so the parties become very adversarial. But as trust builds and as those conversations are held, it should work better. We've certainly seen that it works better.
So would you say that the agency that you used to head up as director, would it be better if they were empowered with more autonomy and more decision-making instead of having to go through OMB and some of the other areas to give that agency more independence and autonomy?
Well, the ability to convene parties and to conduct mediation, I think, certainly is something that has worked well for OGIS. The independence as one of its criteria or one of its abilities certainly helps both with the mediation and also with the reviewing compliance and reporting on compliance. So I think it helps in both respects.
All right. I have exceeded my time. I'll certainly allow the ranking member to do they have called votes. He can do a closing statement if he'd like, and then we'll finish up. But I would like to say that if you have recommendations, policy recommendations, the ranking member and I were discussing, we would love to hear it. We consider this a priority, and we will take action on that. So the chair recognizes the ranking member for a closing statement.
Thank you, Mr. Chairman. Actually, I just wanted to piggyback on the point you were just making, because sometimes when we talk about FOIA, it's good government, it's openness, it's sunshine, and we're just seeking the truth. And we've got bureaucrats who are just stonewalling and not cooperating, and what's wrong with them, and why can't they get with the program? Well, it's not that simple. I was on the receiving end for 14 years of FOIA requests as an elected official in local government, and often the scope of a FOIA was so broad that we didn't know what to do with it. Like, well, if I really responded to what you're literally asking for, would have to hire, huge truck loads of documents to deliver them to you, and it would take forever and lots of money. Can we work together on limiting the scope or being more precise in what it is you're really seeking? And I think that's another aspect of it, because it's easy for someone to say, well, I think you're stonewalling, when the mistake is mine in not being more precise in the request. And actually, it's not because of resistance. It's you trying to figure out what my request is really getting at. And so trying to narrow those differences, I think, is very important so that we do avoid unnecessary litigation and that we try to be more precise in the language of the law when it comes to scope. So thank you for bringing that up, because I think that really is another dimension of this. And thank you to the panel for being here today.
So I'd like to thank the witnesses for taking the time to appear today. If there's no further business, without objection, the subcommittee stands adjourned.